All right, so that's on green. We'll get going. So my name is Matt McClintock. I'm founding partner of a law firm based in Evergreen, Colorado. Our law firm is focused exclusively on sophisticated estate planning for ultra affluent clients, by which I mean clients that, married couples who have probably $40 million or more total aggregate wealth. We've got a growing number of clients who have several hundred millions of dollars worth of aggregate wealth. And in 2017, we got our first Bitcoin client. I didn't know anything about Bitcoin other than stuff I'd heard about, didn't care about it, it was not on my radar. But we had as a lot of our clients come in through co-counsel engagements with other estate planning attorneys around the country, just because of our focus. And it was in that vein that a colleague of ours in Boulder, Colorado, said, "Hey, I've got this client. They're worth about 150 million. Are you interested in talking with them?" I said, "Well, sure. That's what we do." She said, "Well, we got about $100 million worth of Bitcoin, $50 million worth of real estate and other assets. Really interesting guy. I think you'd like to get to know them." So, "Well, that's great. I have no idea about Bitcoin." Started doing a little bit of research on it. And then, of course, all the clickbait opens up and you start to see this little road and you start learning about money laundering and weapons transactions and all this really scary, nefarious stuff. And so, but I started finding some other interesting stuff too that was, and I started doing some due diligence on this prospective client. So I sat down with a prospective client, with his family, and was really kind of drawn into the story, drawn into his personal journey with Bitcoin. He had gotten in 2011. He had built and sold a succession of very successful Bitcoin-oriented companies. He had a massive Bitcoin purse. He had been liquidating over time and going into real estate and other types of holdings, and is still actively involved in the Bitcoin community. So I just found it fascinating. We ended up doing a whole lot of sophisticated, tax-oriented, asset protection-oriented, privacy-oriented, multi-jurisdictional estate planning for this client. And then he is still, to this day, a very active client in our practice. And that, I was able to develop a good relationship with him through that, with a few other kind of early founders in various projects. And then before long, I find myself just, pick your analogy, I've been red pilled, I've been falling the bottom of the rabbit hole the whole bit. And so we started receiving Bitcoin as compensation in our law firm in the first quarter of 2018. We've now, just over the course of, it's really accelerated over the course of the last 12 or 18 months. And now the vast majority of our practice is comprised of crypto affluent folks. We've got clients, mostly US-based clients. We've got a handful of international clients, but most of our clients are US citizens, US persons for tax purposes. And we do planning all around the country. One of the reasons why I'm here in Wyoming is because I think, as most of this audience is aware, Wyoming has got the most favorable body of crypto asset laws on the books. And couple that with Wyoming's very favorable tax laws, very favorable privacy laws, LLC laws, trust laws. It just makes it really the sweet jurisdiction for crypto asset related estate planning. I was talking to another person earlier today. If you kind of net out the crypto side of things, I actually don't think that Wyoming is the number one jurisdiction for a lot of sophisticated estate planning. It's great. I'd say it's kind of midway up the second tier, but South Dakota is better, Nevada is better, Tennessee in some respects is better if you net out crypto. But Wyoming still has excellent trust laws, excellent tax laws, excellent LLC laws. But when you then layer in crypto, when crypto is in play, if you're onshore in the US, you really have one jurisdiction to choose from, and that's Wyoming. So we do a ton of estate planning work for in Wyoming. And like I said, this is the dominant theme of our practice. Just a quick side plug. If you are, or if you know of attorneys or aspiring attorneys who are interested in working in a practice, we are varied, and we would love to talk to people that you know who are interested in maybe diversifying their practice. We're literally hiring now. So this is my contact information. Feel free to reach out to me. I'll talk with the IT folks here, but I did not circulate my slides beforehand because I didn't know how to do that and they weren't ready. So, but feel free to connect with me on LinkedIn. Because here's my email address. You can email me directly. We love collaborating with other attorneys. We love collaborating with other financial advisors, CPAs. You think there's too much work to go around. So quick disclaimer, I'm not sure who's watching online. Unless you're my client, this is not legal advice. If you're my client, let's talk. We're going to talk a little bit about, this is going to be our agenda for the next 43 minutes or so, maybe 3 minutes or so. We're going to talk a little bit about the practical fragility of digital wealth. There's a lot that's given into this whole kind of, this idea of anti-fragility. And, as we all understand, the bigger a blockchain gets, the more diverse a blockchain is, the more nodes that are operating the network, the less fragile or the more anti-fragile that network becomes. So the assets themselves are not fragile. In fact, they become very anti-fragile. However, the ownership of the assets, that can become very fragile because the whole idea of your private keys, if you don't have a good succession protocol around managing those private keys, the wealth that you accrue in digital assets could easily be lost if you become incapacitated. They could disappear forever if you die. If you give those private keys to somebody else, they can, of course, abscond with those private keys. And so one of the things that we're navigating right now with clients investing any wealth in this space is helping them think through how do you create some anti-fragility around the private keys that control your crypto. We'll talk a little bit about the tax issues. There's not a whole universe of tax policy that's out there yet, but we'll talk about what's known. We'll talk about what may be pending under the House Ways and Means Committee proposals that are going on right now in DC. We're going to talk about some of the mechanics of some sophisticated estate planning strategies that we're using every day in our practice. And then time permitting, I'll actually get into some of the specific trust design considerations that, regardless of the level of a client's wealth in crypto, need to be contemplated even in the most foundational basic estate planning documents when crypto assets are at play. So the trust design considerations, when we get to that part, think that this could go into a will. This could go into a revocable living trust. This could go into a durable power of attorney for property. So some of the stuff that we're going to talk about, a lot of what we're going to talk about is going to be targeted to the ultra affluent because that's just where our world is. But a lot of these concepts can be distilled back down to hodlers, traders of just a modest wealth. Not going to really talk a whole lot about the economic model here. This is not really an economics session on crypto. And if you're participating in the Wyoming Blockchain Stampede, you already kind of have some understanding about the economic value of putting Bitcoin or other crypto assets as part of an investment policy. But it's this kind of data showing the traditional return on investment, the Bitcoin versus traditional ROI compared to gold, compared to the S&P 500, compound annual growth rate. The numbers are just ridiculous. ROI year to date, even as Bitcoin had a massive beat out, actually a couple of times this year, it's still up. Year to date, it's still up 44%. If we pan back out 3 years, it's up over 548%. 5 years, it's up almost 7,000%. And so what our clients are seeing, because they're financially savvy, they understand that, depending on when you get into the market, you could be up or down. But if you look at the time horizon, if you kind of pan back out and take a long view, Bitcoin and the broader crypto asset space presents asymmetric growth opportunity, where you can cap your losses, but the upside is just unreal. And as we'll see, some of the strategies that we're implementing for clients create massive, massive leverage for wealth transfer to future generations. And when you're dealing with some of these strategies, if those strategies are sitting on a basket of crypto, then you just knock the cover off the ball from a wealth transfer perspective. So we're going to talk about the mechanics of some of those strategies. But first, let's talk about the practical fragility. We all have heard the adage, not your keys, not your cheese, or not your keys, not your crypto. So this whole idea of being our own bank, and this idea of self-sovereignty, which is core to the ethos of Bitcoin and a lot of the broader crypto asset community, that really runs headlong into a lot of proactive estate planning strategies. Because if I give up my self-sovereignty, now I have intermediaries that are standing between me and my wealth. And so that's a real challenge that a lot of clients have to face, because, again, if I have unilateral self-sovereignty over my crypto and I get hit by a car or I have a stroke, I become incapacitated. If I have not created a very clear path to succession on my private keys, and as importantly, if I've not educated the people in my life that I have it and what it does, how it works, what to do with it, who to talk to, who to trust, then the wealth that I've built is now very much at risk. And we're seeing that even among our young clients, they get this. Because when it was just kind of magic internet money and we're kind of having fun trading and buying stupid stuff online, it's no big deal. But now, as the markets have done what the markets have done, they realize, well, wait a second, this could be transformative wealth. I better grow up. I better do something about it. So we're seeing this, I guess as a quick aside, we see clients of all ages, all walks of life who have crypto. I've been shocked at who has significant amounts of crypto. I've had a 93-year-old grandfather who's been buying Bitcoin since 2014. His family didn't even know. I've had an active client right now is 56 years old. When she divorced, her ex-husband gave her a Bitcoin wallet, 10,000 Bitcoin on it. I kid you not, 10,000 Bitcoin on this wallet. She had no idea. She didn't know what it was. She didn't know how it worked. She didn't realize that at the time it was worth $33 million. Well, now it's worth almost $500 million in one asset in self-sovereign custody. California resident, by the way, at 13.3% income tax on top of your federal. So yeah, that's the biggest one. We've had another interesting client who took a company public. She's another divorcee. She's in her mid-50s. She took a company public a few years ago, done really, really well. And she's grown her wealth. She's made about $15 million in conventional markets just by traditional investments over the course of the last 10 years. She's done really, really well with conventional assets. She came to us. We did a bunch of additional planning for her. We'll talk about some of the strategies we did for her. But now, because the nature of those strategies, she says she's seen the Bitcoin accepted here sticker on my wall at the office. She said, I've heard about Bitcoin. I want inside my GRAT, it's this type of trust that we did for her, inside my GRAT, I want to have Bitcoin because, as we'll see, worst case scenario, the Bitcoin, the GRATs performance fails, the trust collapses and it dies under its own weight. She's no worse off. If the portfolio doesn't perform well, no harm, no foul. But if the portfolio does really well, it becomes a free transfer tax-free gift to her children. So she says, wait a second, if I can beat this minuscule assumed rate of return in my strategy, the extent to which I beat that becomes a free, non-taxable gift to my kids. I want asymmetric upside in that trust. And so we don't advise clients on whether to buy, when to sell, anything like that. But they know that we're in crypto and they understand that, they need to talk to whoever's managing their money or their trustees and get exposure if that's what they're interested in. But kind of back to the thrust of this, part of the challenge that we're seeing in crypto is that even as the industry matures, even as wallet solutions mature, the very decentralized nature of crypto requires different solutions for different kinds of assets. No one wallet handles everything. And especially once you've got enough wealth that justifies multi-signature support or potentially a custodial solution, you may be looking at multiple solutions. That adds layers of complexity and layers of cost. This slide is just designed to remind us all of how big and diverse this crypto asset universe is. There are untold number of tokens out there. Of course, different tokens solve different problems. Some tokens create problems. Some tokens solve nothing, but they all have interesting markets around them. We're seeing a lot of growth actually in our practice in the non-fungible token space. We've got a client who has, he was one of the alpha testers of a big online game called Vulcanverse. Vulcanverse is it's a big open source game that's tokenized. As an alpha tester, he was able to purchase at minimal cost a whole lot of non-fungible tokens in game. Monsters, bits of terrain, campaigns, weapons, whatever. And so he came to me and said, look, these are, according to my estimation, based off of the marketplace values, he said these are probably worth about $4 million. Okay, what are you gonna do with those? So, well, I can actually use those in game. I can level them up through gameplay. And as I level them up, arguably the market value goes up. But, so where's the economic play for you though? Other than just having this, something you can brag about having all these in-game tokens. He said, well, as I level them up in this game, I can lend those assets out to other players and earn a yield. So I can build up this monster here, make it just the very best, undefeatable character in this game, and I can lend it out to somebody. They're going to pay me a yield for that period of time, and then at the end of at the expiration of that smart contract, I get my asset back and I've made a yield. That's kind of interesting. Oh, by the way, as this game grows and as more people come into the marketplace, once I've leveled that up, it's going to be worth 5x, 8x, 10x of what I acquired it at. Okay, that becomes interesting too. So in the non-fungible token space, we got the same issues that we're dealing with fungible tokens like Bitcoin, Ether, other types of conventional commodity type or cash type assets, but we have additional passive income opportunities and property rights that attach these non-fungible tokens that we've got to think about. One of the things that is worth considering in the context of non-fungible tokens, this is, who knows where non-fungible tokens are going to end up, but one of the things that made news, I want to say is around March or April of this year, Kings of Leon famously released an album as a non-fungible token. And so you could actually buy the album as an NFT. But at the time I thought, well, who cares? I mean, why do I want that? Because I can just download it from iTunes, or I can download it from somewhere else. But then the more I thought about that, I said, well, if I download it from iTunes, I don't own anything. I simply have licensing rights under the terms of use agreement at iTunes. And so if they decide to change their user terms, or if I die or whatever, my rights have expired. But if I own a non-fungible token, I own property. Now, I've got to think about that in the context of my estate planning. Now, a single Kings of Leon album may not be worth a whole lot from a financial perspective, but now it creates an opportunity to own assets that we otherwise only had licensing rights to. We're seeing this with photography, we're seeing this with fine art, and we have no idea where it's all going to end up. Anyway, lots of ways for various crypto asset tokens to generate financial or economic value for our clients, whether it's through royalties and use on NFTs, whether it's obviously trading off of volatility, earning income off of yield farming, other types of staking activities, hard forks, airdrops, lots of ways that clients can accrete wealth through crypto asset activities. So as they are building wealth, what do we need to be thinking about from an estate planning perspective? This is not going to be all encompassing. This is just kind of where my head is in this space with a lot of our clients. So when we're talking about clients who have modest hodlings, people like me, not massively wealthy, I'm certainly not an active trader because I don't want that tax headache. But when we're dealing with clients who have kind of modest wealth, it's enough to matter from a planning perspective, but not so much that it's really justifiable to do extensive tax-oriented planning for them. The key focus is creating a trail of breadcrumbs. So if they become incapacitated, they have left a really clear path to the people that they trust to let them know that, hey, I have crypto. These are the wallet applications. Maybe it's a cold wallet. Here's my backup seed phrase. Or if you've sharded your keys, here's, these people have a piece of my Shamir keys. These people have another piece of my Shamir. The other piece of my Shamir is in a vault somewhere. Helping clients just think through and leave a reliable trail of breadcrumbs. We absolutely do not ever put that in the estate plan itself, ever, under any circumstances. We don't put that in a power of attorney. We don't put that in a will. We don't put that in a trust. We don't want that in a document that could somehow be circulating into the hands of other people, therefore letting the treasure map now be circulating beyond our control. So we'll talk about how we will reference that and how we will empower fiduciaries through the design of the legal documents. But the trail of breadcrumbs itself becomes really the very first point of focus for clients who have significant crypto assets. As you can imagine, this has to be a recurring, iterative thing because a lot of our clients are into a lot of different tokens, and they're in and they're out and they're staking, they're yield farming, they're holding, they're trading, they're buying, they're selling. So it's always moving. But we really try to encourage our clients, at least on a quarterly basis, review your trail of breadcrumbs and see what's changed. I don't want to copy that, but I want to make it top of mind for you to make sure that as you are continuing to expand your wealth in this space, you're being proactive and guiding your family. Try to reduce the number of wallets. Try not to have extraneous wallets out there. Again, as the wealth grows, it might make sense to segregate some crypto into different wallets. But generally speaking, you want to try to have as few moving parts as you can, especially if the surviving partner, surviving spouse, inheriting children, backup fiduciary, if they're not necessarily as crypto savvy as you are. We try to render as much advice as possible to make sure that they're tracking their trades, tracking their transactions, so that as they're getting tax, as they're recognizing tax liability, that's getting resolved. We incorporate language based off of the client's priorities that's tailored to each client, but we'll actually incorporate this language in our trusts. We also want to make sure that we've documented the client's intent around crypto, because as we'll see, documenting intent can really go a long way towards helping us avoid application of things like the prudent investor rule and the rules regarding diversification of concentrated positions. We also want to make sure that we're identifying and grooming decision makers who can step into our shoes, who understand crypto. And maybe it's a single fiduciary who can manage your Schwab account, your real estate, your vehicles, and your crypto. Or more often than not, maybe it's one trustee that can manage conventional assets as a special advisor or a special purpose trustee who can manage the crypto. So consider maybe fragmenting out those decision-making authority. And this is something I had to do as Bitcoin. I had this conversation with my wife and kids February or March as Bitcoin had gone from around 9,000, 10,000 at the end of last year to upwards of 60 for a short period of time. I said, we've got some Bitcoin and it's kind of consequential now. So just starting opening up the dialogue. And at first my wife said, well, when are you going to get rid of it? I said, well, when I find something that can perform anywhere close to how this has been performing for us. And she said, well, fair enough. So, but now, I kind of had to come out of the dark a little bit, explain to my kids, explain to my wife how this works, why I'm committed, how this is going to impact our family, what my vision is for this. So they now know. And so we really hope clients will be as transparent as they can feel about being with their loved ones. Once the wealth kind of gets bigger, we're dealing with a couple $1 million worth of crypto. That cryptocurrency is not likely going to be sufficient. We need to be doing some kind of multi-signature solution in most cases, like cost of wallets or something like that. Probably don't, may or may not need a custodial solution like Anchorage. Anchorage is fabulous. We do a ton of work with it. Probably don't need like a full institutional level crypto asset custodian, but we need to be thinking about multi-sig. And depending on what's going on with the tax laws, depending on what the client's objectives are, we might want to start thinking about specific tailored strategies around that crypto. And we'll talk about each of these. And then once we're dealing with bigger wealth, now we're north of about $5 million worth of crypto. We're definitely doing multi-sig. We're most likely doing an institutional custodian like Genesis, Fidelity, Anchorage, any number of these great custodians that are out there. Because it creates this very reliable, very tailored solution. And again, once we're dealing with crypto at that level, we'd better be doing some transfer tax-oriented planning. If we're doing transfer tax-oriented planning, we have to sever the client's unilateral control over those assets. One of the things that is, I want to make sure I'm tracking on time. So far, so good. One of the things that we kind of learn in Estate Planning 101, way back in our wealth transfer tax class in law school, is this concept of dominion and control. Maybe that's kind of bringing up some light bulbs for some people that, yeah, I've heard about that. If I have dominion and control over my assets, then from a transfer tax perspective, that is includable in my estate when I die, so long as I have that dominion and control. If I want to make a gift to transfer that asset away from myself to someone else, whether it's outright or whether that's in a special type of trust, I have to sever that dominion and control. And through thoughtful development of a multi-signature solution, especially at a custodial level, we can clearly sever that dominion and control, get the value of assets out of our client's estate, and most importantly, get all the future growth on those assets out of their estate as well. These custodians are not inexpensive. You also have, to a certain degree, counterparty risk with the custodian. And one of the reasons that we've shopped around custodians for a little bit is because if you want to make a liquidation, especially of a larger amount, it may take some time. to liquidate a significant position through an over-the-counter trade or something like that. Let's talk about the taxes, what we know. The first guidance that our industry got was IRS Notice 2014-21. I'm not going to go through this ad nauseum, but the essence is that the IRS says that we're going to tax it like property. So your Bitcoin, your Ether, your Apple stock, your Tesla stock, your piece of real estate, they don't really care. When we receive payment, for example, in Bitcoin, that is the capital gains tax recognition event for the client who pays us in Bitcoin. They're going to recognize capital gain or capital loss on the value in US dollar terms that they paid us. Now, when we receive that, it's just like we received Apple stock or Tesla stock, so it's ordinary income to us at our ordinary income tax rates as valued against the US dollar. And once we receive that, that starts our holding period for capital gains tax purposes. So when we later dispose of that asset, then we're going to pay capital gains tax, or we'll recognize a capital gains loss subject to our holding period, long-term or short-term capital gains. That's the upshot of IRS Notice 2014-21. Then we got a revenue ruling 2019-24, starting to deal with hard forks and airdrops. The upshot here is when a transaction occurs, you receive tokens in an airdrop, you receive tokens through a hard fork. If you have what the IRS calls accession to wealth, if you can do something with that, if it has monetary value, that is an income recognition event for you. Now, if it's locked up for some reason, if there's no trading opportunity, or if it's valued at zero, then it's not a taxable event until such time as it has value and you can do something with it. This risk is getting a little bit wonky, but hard forks and airdrops are really challenging because, in the estate planning world, you strip away the crypto for a second. In the estate planning world, we deal with this issue called a general power of appointment. If we have a general power of appointment over property, for example, in a trust, if I have the ability to appoint property from a trust in favor of myself, my creditors, my estate, or the creditors of my estate, if I can appoint property to any one of those, I have what the IRS calls what the Internal Revenue Code calls a general power of appointment. And the value of the property over which I have that power is includable in my estate when I pass away. So one of the strategies that we've done periodically for clients is as we design trusts, we might give someone else a general power of appointment over the assets in a trust in order to cause estate inclusion when they die. Why would we do that? Because right now under the tax code, when that person dies, we get to use their estate tax exemption, and most importantly, we get a basis adjustment on the value of the assets inside that trust. So it's a really cool way to cause estate inclusion, use an estate tax exemption that's otherwise not going to get used, potentially use a generation skipping transfer tax exemption over assets that we might not otherwise get a GST exemption over, and get a resettlement basis for capital gains tax purposes. Airdrops work the same way. Okay, airdrops work the same way. An individual who has a general power of appointment doesn't even have to know they have it. Simply having the power causes estate tax inclusion. Same thing with an airdrop. You may not even know somebody airdrops tokens to you. You may not have even wanted them. But if you got them, and if you have an accession to wealth as a result of that, you've got tax liability. We know the Treasury is sharpening their focus on crypto. Don't need to go into this a whole lot, other than to say there is widespread belief, fully merited in Washington, that a lot of cryptocurrency, crypto asset transfers have not been properly reported from a tax perspective. And so the IRS launched this kind of ridiculously named Operation Hidden Treasure. I think it's dumb how they do these things, but they launched this year. It's a joint effort between their criminal fraud and their criminal investigation and their fraud enforcement to really focus their efforts on this. I've got some citations in the materials if you want to learn more about that. Tesla's case is going on right now in the U.S. District Court in Tennessee. And this is going to deal with, this is hoping to resolve how are we going to deal with staking rewards and how will those be taxed. The taxpayers here file their taxes, they acknowledge the staking rewards, paid the tax liability, and they turned around to sue for a refund. That is now pending. Don't know how that's going to end up. We've all heard about this Build America Act of 2021, where the definition of brokers has been really, really mushy. I know actually Senator Lummis and a few other legislators tried to get some amendments through to clarify what a broker is for purposes of being able to provide tax reporting information. That amendment did not get through. It's currently sitting in the Senate and been passed by the Senate in unamended form. Hopefully we'll get some clarity around what that means. Okay, so now we understand a little bit about how things are taxed from an estate, from a crypto perspective. We can then think about, okay, what strategies can we bring to bear for clients who have significant crypto asset wealth that can provide some meaningful outcomes for them? Well, I mean, spoiler alert, the same strategies apply. The same strategies that we would use for a client who has massive conventional wealth, we can use for crypto. It's the mechanics that get really hard. We gotta draft the documents really carefully. So that it's like a GRAT I use for real estate is gonna be different than a GRAT I use for crypto, but the GRAT works in each case. We've got to navigate the crypto specific provisions, and as importantly, if not more importantly, we've got to find the right fiduciaries who can manage those assets. So let's talk about some of these strategies we think are particularly crypto friendly. Now, there's a huge caveat on this because a lot of the strategies I'm going to talk about are endangered species. They're circulating from the House Ways and Means Committee as part of the tax reform that's being promoted through Washington, would kill or kneecap most of these strategies. We'll see what strategies open up. One of the things that we always talk about in estate tax planning is every tax bill is simply our Full Employment Act. There will be new strategies. There will be new opportunities. We'll be as busy as ever. But some of the stuff that we're gonna have to adapt. As I think most people are aware, the current federal estate tax exemption is $10 million per individual, adjusted each year for inflation. And that was enacted in 2017, the prior administration. Because of how the indexing works, because of how tax bills work generally in DC, there's a sunset built in. This tax policy has a built-in expiration date. So the exemption currently is $11.7 million per U.S. citizen taxpayer from a gift, estate, and generation skipping transfer tax purpose. That is already set to expire at the end of 2025. When it expires, the exemption gets cut from $10 million plus inflation indexing to $5 million plus inflation indexing retroactive. And so we already knew that the estate and gift tax exemptions were scheduled to come down. So we kind of thought, my philosophy had been, why would Democrats kind of poke the bear and go after the estate tax, since it's a problem that will solve itself in a few years? But the House Ways and Means Committee is now proposing, hey, let's just sunset this thing now. So we might find ourselves January 1 with an estate tax exemption that's been cut in half, which now means a whole lot more Americans are going to have federally taxable estates. As I alluded to just a minute ago, grantor trusts, irrevocable grantor trusts, will be effectively decapped. They won't have a lot of juice, and importantly, if this gets enacted, we don't have until January 1 on the Grantor Trust rules. The provisions concerning Grantor Trusts would be applicable as of date of enactment. So that could be as early as next week. That could be sometime mid-October, who knows? But if this gets passed, Grantor Trusts are dead, which means that on an irrevocable Grantor Trust, one of the most foundational elements we've done for wealthy families, the full value of all of the assets in a Grantor Trust established after the date of enactment will be includable in your estate when you die. In an irrevocable Grantor Trust, even if you intended that to be a completed gift at the time of the transfer, any distributions from the trust to a beneficiary is treated as a taxable gift back to the donor. If you turn off the Grantor Trust status and turn it into a non-Grantor Trust, which we'll talk about, that conversion event recognizes tax on the full value of the trust. And then any sale to Grantor Trust after the date of enactment would be would trigger taxable gain.
Yeah, this is a super naive question, but with retroactivity, so you and I sign, I'm your client, we sign a deal this week, and then the tax bill passes next week. It's not retroactive because it doesn't operate until I die in the future, or is it, you can't have different tiers of laws through time of like, this trust is okay because it was created in 85 and this one in 95. So there's not a retroactivity problem because I haven't died yet.
So it's not usually the fact that you have not died yet. It's simply a matter of if the transaction is complete and then enactment takes place. I know this is kind of a politically charged term, but usually trusts, strategies that are implemented before the date of enactment are grandfathered in. And so you usually don't look back and unwind tax policy and apply to strategies that were enacted, that were in place at the date of enactment. That has happened before. It happened under the Clinton administration. I believe it happened once under the Obama administration, but in both cases, we were not nearly as far along in the year as we are now. So I think that arguments of fairness would kind of start to kick in. And so if you're a wealthy person and you do some type of $20 million transaction, it's my perspective right now that would be safe on a go-forward basis. The laws would only apply to future transactions after that date. Now, if you created your irrevocable Grantor Trust now and you funded it today, and then the law changes next week or next month, if you engage in a future transaction with the trust that you created before the date of enactment, that taints the trust. So once the date of enactment takes place, no future transactions could take place between you and your Grantor Trust without tainting it and causing adverse tax consequences. That's the understanding right now. And so this is just proposal, not worth getting too bound up on, other than the fact that this is showing some signs of significant momentum in both chambers of Congress. So it's worth thinking about. Also, kind of key to this is a lot of us have been using valuation adjustments, often referred to as valuation discounts, on closely held family entities using like investment limited liability companies, ratcheting down the value of the LLC through restrictions inside the trust, and then being able to leverage out more wealth in irrevocable trusts. Those will be dead. Those will be gone if this becomes law. So those things will not work anymore. So let's talk about some of the tax favored strategies and some of the mechanics of how these work under the current law. This is what we've been doing. This has been bread and butter for us for the last handful of years. We're going to talk about split interest trusts, and I'll throw some acronyms around like GRATs and CLATs and flip cruts. It's part of the ridiculous spaghetti alphabet soup that we use in our industry. But we'll talk about how those work, and we'll show why, from a quantitative perspective, they really move the needle from a wealth transfer perspective. We'll talk a little bit, hopefully time permitting, about leverage sales to irrevocable Grantor Trusts. And because we're in Wyoming, I've got to do a nod to Wayne's. irrevocable non-grantor trusts. Talk about how those work and what they do and why you might want to think about it. I like to use the acronym I like to use the word irrevocable as my I and ing because an irrevocable non-grantor trust could be a completed gift for transfer tax purposes or an incomplete gift for transfer tax purposes, depending on the trust design and what you're trying to accomplish. Usually, you think of it like it's a Wyoming incomplete non-grantor trust. It could be complete or incomplete. So we refer to it as an irrevocable non-grantor trust. We're also doing a lot of work around philanthropy for our crypto asset clients. One of the things that should be immediate low-hanging fruit for any client in this space who has recognized significant gains this year. As a holdover from 2020, they could make an unlimited cash gift to a qualifying charity and be able to deduct up to 100% of their adjusted gross income for 2021. Usually it's in the 50 to 60% range, subject to a 5-year carry forward. But as a holdover from the COVID relief package that was enacted in 2020, they could actually do that in 2020, make a cash contribution in 2021 to a qualifying charity and be able to deduct up to 100% of their adjusted gross income. So they could wipe out their gain simply by stroking a big check to a qualifying charity. Grantor CLATs stands for Charitable Lead Annuity Trust. We'll talk about the mechanics of those. Charitable Remainder Unit Trusts, we'll talk about how those work and how that can be really interesting from a crypto perspective. And we're actually in the final steps of creating a private operating foundation for a client who's got massive Bitcoin holdings. So what's a split interest trust? How does it work? Why would you do it? Well, think about what we're doing here. We are splitting the interest in a trust. A trust is comprised of a lead interest and a remainder interest. So I, as the grantor, can create an irrevocable trust. That makes it usually a completed transfer for transfer tax purposes. And so I can, as I design that trust, I can say that this beneficiary gets the lead interest or an interest from the trust for a specified term of years. And then the remainder at the end of that term goes somewhere else. The lead beneficiary might be me as the grantor in the case of a Grantor-Retained Annuity Trust, with the remainder passing to my beneficiaries down the line. The lead beneficiary could be a charity in the case of a Charitable Lead Annuity Trust, with the remainder passing again, usually to my children or other beneficiaries down the line. Or the lead beneficiary could be me or someone else, with the remainder passing to a charity in the case of a Charitable Remainder Trust. They each solve different problems. So this fourth bullet on the list here, this is where the economics get really interesting, especially in the case of these lead trusts. The way the trust is designed, the value, when the trust is established and funded with assets, we have to calculate the value of the lead interest that we have retained in the case of a GRAT, or the value of the lead interest we have given to charity in the case of a CLAT. And then we have to determine the value of the remainder that will then pass to our other beneficiaries. And it's the value of the remainder that becomes the taxable gift for federal transfer tax purposes. Now this Section 7520 rate that's referenced on the slide here, the Section 7520 rate is an imputed rate of return based off of a lot of economic factors, and it's published by Treasury every month. So the idea here is that you look at the value of the assets going into the trust, you look at the value of the lead interest that you've calculated, and you say, well, based off of those factors, I can estimate the value of the remainder growing at this hypothetical rate of return under Section 7520. That tells me what my tax liability is on the remainder interest that passes to my kids. So we can see that the lower that 7520 interest rate is, the easier it is for the trust portfolio to outperform that hypothetical rate of return. We'll look at the numbers. It'll make more sense as we look at the numbers. Because the cool thing here is this last bullet, that 75/20 rate, right now it's 1.0%. What that means is if you create a GRAT or if you create a CLAT and the assets inside that trust grow at more than 1%, the extent to which it exceeds 1% growth becomes a non-taxable gift to your remainder beneficiaries. So here's just a quick mechanic. A lot of these work the same way, but our settlor, an individual who creates the trust, makes a gift into a Grantor-Retained Annuity Trust. Because she is the grantor, she has retained the annuity for a period of time. Now, we designed these to where the value of the remainder effectively makes the net gift to beneficiaries as close to zero as possible from a tax perspective. And the way we do that is based off of the 75/20 rate. So if we say that the value of what our settlor retains is equal to the full value she puts in, then she's made a net gift effectively at zero to the beneficiaries. But we have to assume that the value of the portfolio is growing at our 75/20 hurdle rate. But if we outgrow that hurdle rate, the extent to which we do outgrow that is a tax-free gift in protected trusts to our beneficiaries. Here's a quick run of the numbers. Super simple scenario here. Let's put $1 million into a Grantor-Retained Annuity Trust, and let's do it at the end of this month. So September 30th of this year. We get to use the 1.0% hurdle rate for calculating the value of the remainder. We put $1 million in, we design the amount of the value of the annuity to our settlor. We value that at $999,999.85, which means that she is pulling back out almost everything that she put in, assuming that it's growing at 1% each year. So we value her annuity each year based off of a hypothetical growth rate of 1%, because that's what the IRS says we use. But if our trust grows at 20%, which if we're talking about the S&P 500, that's ridiculous. If we're talking about Bitcoin, it's ridiculously low. But when we illustrate this to clients and say, let's just can I say shits and giggles? Sure. If we, just for shits and giggles, we put it in at 155%, which is the CAGR for a 30-year period of time on Bitcoin, numbers they're obscene. So we said, look, let's ratchet it down and say if Bitcoin has a terrible year, you're probably getting 20% over a 3-year period of time. Well, look, we've made a taxable gift that will use up 15 cents worth of our clients' federal estate tax exemption. But if we get the 20% return on the portfolio, that means that at the end of 3 years in a GRAT, it has cost us 15 cents worth of our tax exemption to put over $500,000 into a protective trust for our beneficiaries. This is how GRATs work. The bigger this number gets, and the longer the trust runs, the bigger this number gets. No, it's not without risk. But it's the mechanics of this is what has a lot of which has the Democratic Party and kind of the tax reform favored people really hate GRATs. This is one of the because the leverage is ridiculous, and especially if you put pre-IPO stock, or if you put real estate in Jackson, Wyoming, or Evergreen, Colorado in there, you're probably not making 20%, but you're making better than the S&P. But then if you put crypto in there, you just rip the cover off the ball. Grantor CLATs, think of a CLAT, it's the same as a GRAT, except that instead of you as the grantor retaining the annuity, you're giving the annuity to a qualifying charity. Why would you do that? Well, it's really great if you've had a lot of tax liability accrue this year. Maybe you've harvested some gains off of your Bitcoin, maybe you sold it when it was at 63,000, got a lot of gain. Well, as a post-gain recognition strategy, currently you can create an income taxable grantor charitable lead annuity trust. You put $1 million in, you get a near dollar for dollar income tax deduction this year, subject to a 5-year carry forward, if you can't use all the deduction in a single tax year. Again, the mechanics are the same though. To the extent the growth of the portfolio in the CLAT outperforms Section 7520 rate, we've now made a free gift of the remainder to our beneficiaries. Now, CLATs are cool because with a Grantor-Retained Annuity Trust, if you die during the initial term of the trust, let's say you create a 10-year GRAT and you die in year 8, at least a part of the value of the trust gets dragged back into your estate. Depending on what federal district you live in, it might be the total value of the trust. Most jurisdictions, it's going to be just like a percentage of the value of the trust. But that problem does not exist with CLATs. So we can create a CLAT. Let's say that we've done one here. This is a 15-year CLAT that we did here. Using, again, the Section 7520 rate of 1%. We backload the CLAT, which means that the value of the annuity will increase each year, meaning that we get to sit on more money inside the trust, growing above the 7520 rate before we make our distributions to charity. So the amount of charity will taper up over time, but the value of the trust is swelling to create a bigger remainder for our beneficiaries. So here's what we've done. We put $1 million in a 15-year charitable lead annuity trust, and we've designed this to where the value of the remainder for tax purposes will use up $22 worth of our $11.7 million exemption. So for $22, we get to create a gift of $13.3 million to our beneficiaries. It cost us $22 worth of our tax exemption to make a tax-free gift of $13.3 million. It's bananas. The numbers are crazy because crypto is so volatile and it's so powerful. One more strategy. Well, 2 more strategies. We can do this really quick, I hope. A flip CRUT, charitable remainder unit trust. This becomes a really interesting strategy pre-liquidity, pre-recognition. What happens here is we create the trust. Maybe a husband and wife create this trust. Maybe a single person creates this trust. They put appreciated assets. They've not recognized their gain yet. They put appreciated assets like closely held stock, like Bitcoin, whatever, inside this trust. And they retain the right to receive either all the income from the trust or a percentage of the value of the trust each year. And so what happened is that the value of this has to be designed in a way that the value of the charitable deduction is at least 10% of the value of the seed gift. Now, this is kind of perking along. Maybe we're not ready to sell our Bitcoin yet, but maybe at the end of the cycle, when things are nice and frothy and Bitcoin's 150K, maybe then we'll pull the trigger. Well, let's put our $44,000 Bitcoin in here. And when it hits 100, 150, then we'll sell. What happens? Well, this is now the owner of the Bitcoin through a custodial wallet or some other type of structure where we've severed dominion and control. This sale transaction takes place in an income tax-free environment. Why? Because the charitable remainder trust is a non-taxable entity. So then we sell out our $10 million worth of Bitcoin holdings. That $10 million, and it's zero basis, basically. We've been mining it since 2009. There's no gain recognition event at the time of sale. Now, when we as the settlors take out our distributions each year, each distribution will carry with it a percentage of the tax liability to us, but we get to defer the tax liability over a much longer period of time And once we're kind of north of our mid-50s thereabouts, it actually works that we can stretch that out for the duration of our lifetimes. So now we've got free access to capital to reinvest, go build something new, buy more crypto if we want to, but we get to defer all the taxable gain on our asset event. Just want to say one quick thing about names, irrevocable non-grantor trusts. What's the big deal? For clients who live in high state income tax jurisdictions like California, like Oregon, Illinois, handful of jurisdictions like that, this becomes a state income tax play. The trust is designed as a separate taxpayer for federal income tax purposes. Now that's a saw that cuts both ways, because trusts get to the highest marginal tax bracket much faster than individual taxpayers do. If it's a grantor trust, we're under the individual taxpayer tables. But if it's a non-grantor trust, then we will get to the top marginal tax bracket at about $12,000 worth of annual income. Plus, we'll get a 3.8% net investment income surtax. Plus, we'll probably also get a 0.9% Medicare surtax. So we're going to get up into higher federal tax brackets much faster than we will if it's a grantor trust or if it's us as an individual. But if we're in California, where we're subject at the high level up to 13.3% state level income tax, or Oregon at 9.9, then these can start to make some really interesting cash flow models. Also, this is something that's often overlooked, and this is not, we want to make sure that the tail's not wagging the dog, but non-grantor trusts can become interesting solutions for owning high-value real estate. Because, as we know, at least right now, the SALT deduction, the state and local tax deduction, is capped at $10,000 per taxpayer. Non-grantor trusts allow us to create multiple taxpayers, and so now we might have one Wyoming irrevocable non-grantor trust that owns our vacation property in Newport Beach. Maybe another one owns our cabin in Aspen. Maybe another one owns another piece of property somewhere else, and we can stack our SALT deductions that way. And also from a qualitative perspective, there are often a lot of additional privacy and asset protection oriented benefits to these types of trusts that are worth considering. So the rest of the slides, and we really didn't get time to talk about the trust design considerations, so I apologize for that. I will happily share these materials. If you want to grab me after the fact, you can grab one of my cards, pop me an email. I'll be happy to share these with you. Regardless of the level of wealth, we have to be thinking about the client's crypto asset wealth as real wealth. It's really complicated wealth, but it's really, really important. We've got to navigate the prudent investor rule. We've got to help them identify appropriate fiduciaries. We've got to help them create an investment policy statement or an investment thesis around crypto, manifesting their intent to hold crypto. And we also need to be really mindful of what jurisdictions we're putting their trusts in, even if it's a revocable living trust. So I'm long, I apologize for that. I will leave some cards here. I'll be kind of floating around a little bit. So thanks a lot for your attention. Really appreciate the opportunity to present here.